he's still subject to prosecution.
Trump specifically is still subject to prosecution because many of them couldn't be possibly considered official acts.
Right. I don't think that the false electors scheme is anything to do with his official authority and exercise of official power. I don't think the lip speech was. The lip speech was essentially a campaign speech after the campaign was over, an attempt to overturn the election and to have the president be able to try to coerce the legislative branch into basically committing a violation of the Constitution. I mean, that should be an act that can be criminal.
Hello, everyone, and welcome to George Conway Explains It All. To Sarah, I'm Sarah Longwell, publisher of the Bulwark, and because I'm not a lawyer, I asked my good friend George Conway from the Society for the Rule of Law to explain the legal news to me. And yesterday was the day. We finally got an opinion from the Supreme Court in the immunity case. But before we dive in, just to level set here, I want to play a clip so that we can remember what these justices said during their confirmation hearings about executive power.
A president is not above the law with respect to the criminal process.
I believe that no one is above the law under our system, and that includes the president.
And nobody is above the law in this country, and that includes the president of the United States.
No person in this country, no matter how high or powerful, is above the law.
No man is above the law.
Oh, old times.
Yeah, that was good. Okay, so that was then, this is now. The Supreme Court held, and I'm quoting here, that under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. And he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. I don't know, George. It sounds like he's above the law to me.
He's kind of sort of above the law sometimes for certain purposes and certain things.
Okay.
And exactly what those things are, we don't necessarily know. And people are going to be debating that for years. And this opinion, it both decided way too much and way too little. And as a result, it's kind of a confusing mess, and I'll try to explain it to you as best as I can.
Wait, before you explain it, though, can you tell us, were you, because we've talked about this case a lot, we've been waiting for it, how surprised were you that this is what they did?
I'm moderately surprised. I think I'm not surprised that they basically rejected the the Trump position that was more absolutist. That said, they left a lot of air for non-prosecution of presidents for crimes. I don't think it necessarily helps Trump in this case, other than the delay and the hoops that the prosecutors have to jump through, and I can explain that in a bit. I think the problem was, as I said, they decided both too much and too little. They basically didn't decide this case and took it upon themselves to decide every other conceivable case that could come down the pike, even though, this is a once-in-a-lifetime case, and even though it's just hard to imagine all the different kinds of crazy hypothetical circumstances that could arise and never rise. And I think we've talked about that in prior podcasts about, deciding things. We just can't foresee the future. I think it's right for the court to try to set out general rules that apply to more than one case. That's their job. But there are times when trying to create a theoretical framework to decide all things for all times, to write an opinion for the ages, I think was a phrase that I think Justice Gorsuch used at the argument, is just not productive, and it does more harm than good. And I think that's the circumstance here. The impression I got out of Chief Justice Roberts' opinion, where he says, but in addressing the question today, unlike the political branches and the public at large, we cannot afford to fixate exclusively or even primarily on present exigencies. What is going on here? It's we're not going to decide this case. Who tried to launch a coup? What difference does that make? I mean, that's essentially what they did here.
Yeah, so he's saying we're not going to think about this in the context of Trump and what he just did.
We're not going to think about this case. Who killed him? Who cares? I mean, who cares? Who cares that the president of the United States tried to extend his term in office beyond after losing an election? I mean, and that's the fundamental problem with this opinion, is it never ever really comes to grips with the facts of this case and decides things that it shouldn't have to have decided, and then tosses up, as far as the facts of this case are concerned. Basically, they just say, they punt. And they just say, well, it could be this, it could be what Trump is saying, even though, I mean, anybody in their right mind knows Trump's arguments are bad faith.
Yeah.
And just basically puts it up in equipoise and throws it back to the district court. Okay? And that's the problem with the opinion. It decides too much and too little at the same time. It basically decides a case that wasn't presented to the court. Now, let's go.
Can I just do the too much, too little? This is because you're saying they decided that the president has immunity for official acts, but not unofficial acts, and then there is a presumption of innocence.
Let me go through.
Most acts.
If I go through this chart, you can just see how it is basically. You'll see how they created this whole structure that was just unnecessary to decide the case and just made it much more complicated.
Okay.
And for this
Hit
purpose,
me with your handwritten bubble chart.
The handwritten chart is the masterful creative work of my friend Asha Rangappa, who loves to do these charts, and she does these masterful charts illustrating all sorts of things. And I think this, if you want to understand this opinion, you should look at this flow chart. And basically what the court does is the court says, okay, first of all, we're going to say that there are some things that the president is charged with doing that are absolutely immune from criminal prosecution. And they get those core, that's the first question at the top of this chart. Is it a core or exclusive Article III function or authority? And they get that from a famous case called Youngstown Sheet and Tube Company versus Sawyer, where the court struck down President Truman's seizure of steel mills during the Korean War. And there was a famous concurring opinion, which I think we've mentioned in the past, by Justice Robert Jackson, where he says that the president exercises three kinds of powers. One is where he basically exercises it alone because the Constitution gives it to him. And that's like, for example, the right to command armies. Mm-hmm. Then the second is things where Congress can regulate it, like that would be like the spending of money and for the armed forces. That would be something he couldn't appropriate the money to fund the armed forces, but the Congress can't command him to use the armed forces. So that's the distinction between the first and second. And the third is things that he just can't do. Okay, and
he cannot seize the means of production.
Right, he cannot seize the means of production. That was the problem, and that was the problem in Youngstown. So they're saying there should be some parts where you just can't touch what the president is doing, and I get that. I mean, there was a suggestion by a professor at NYU, a liberal professor, who basically agrees with us that Trump should not be immune for any of this, and he just said, well, there do have to be some limits, and I get that. Unfortunately, what the court did here was it got too specific and tried to decide all the different circumstances that could possibly happen by setting up this framework, and so they create this absolute immunity, which I get. I understand there may be some things that you just can't touch, that Congress can't interfere with because it would harm the presidency. But I don't see why it's productive to really kind of get into that now. And then they do one more thing. If you go down here, they say that you can't inquire about the motive of the president. You cannot charge conduct that is related to that core conduct, that core conduct, and you cannot even use it as evidence of intent. Okay. Now, where that lands here is, they say here in this when they apply the facts, this law to the facts of the case, they say that the discussions between Trump and the acting assistant attorney general, whoever it was at the time, and all these people in the Justice Department are, core discussions because they involve the power to prosecute, and that's discretion on behalf of the president.
So he's talking to John Eastman, and he's saying...
he's talking about... John Eastman wasn't right, but he was basically talking about the conversations he had with Clark and those people about that. They're basically saying...
About overturning the election.
About using the Justice Department to overturn the election.
Yeah.
And to me, that's just ludicrous, okay? It's not... First of all, it's to say that is... that you can't look at the motive there is absurd. Because it's not, there's no basis. It was not in good faith. It was not even close to being in good faith. And to put that within the Article 2 core function and give it absolute immunity, I think is just a gross overreaching. Even though in the abstract, I think there should be some core conduct that could be that could be completely protected or mostly protected or presumptively protected. Okay, so that's one branch. Now, the rest of it, you show, it says, the rest of it turns on whether or not the conduct is otherwise official acts or unofficial acts. So there are other kinds of official acts where, that fall within the outer perimeter of the executive authority, which is the language that they used in Nixon against Fitzgerald and Clinton v. Jones to deal with civil liability. And what they're basically saying is that if this non-core conduct that is nonetheless within the power of the presidency is implicated, then there is a presumptive immunity, but the presumptive immunity can be rebutted. And the test is an incredibly mushy one. The test on whether or not the prosecutors can overturn this presumptive immunity, it turns on whether or not it's found that there's no potential danger to the presidency and the power of the presidency. And who knows what that means. But And that's another problem. It's just incredibly vague. And again, there's this whole section. If you look at on the chart on the right, okay. So the test is: would prosecuting intrude on the authority and functions of the executive branch? In other words, is prosecuting this case in some abstract sense bad for the presidency? And if you say no, then you go over and you can say, you can look at the motive and you can inquire and you can charge conduct and you can charge it. Okay.
We got to take a quick break and pay some bills. George, our sponsor today comes from OneSkin. I know I'm ready for summer, but that doesn't mean my skin is. That's why it's great that I have OneSkin to help me enjoy the season. Their OS1 peptide, this is the one that targets the zombie cells that cause lines, wrinkles, and sagging skin, is scientifically proven to reverse skin's biological age at the cellular level. You look like you've been doing aging in reverse. So whether you're lying on the beach, hiking, or heading out on vacation, OneSkin's OS1 powered sunscreen block UV rays while targeting the UV-induced skin aging you already have. I love all of their products, but I'm really excited about their new limited edition bundle, Summer Skincare Essentials, which includes their daily moisturizers and broad spectrum sunscreens for the face and body. I have on the sunscreen right now. For a limited time, our listeners will get an exclusive 15% off their first OneSkin purchase using the code AskGeorge when you check out at oneskin.co. As summer heats up, give your skin the UV protection, hydration, and cellular support it needs with OneSkin. It's pretty great, isn't it, this stuff? I know you use it.
It's amazing.
Yeah?
It's amazing, and I've been using it.
You look 10 years younger.
Oh,
your zombie skin. I can't see any of your zombie skin.
No, we were both out in Aspen, and I had the travel kit.
Yeah.
They have these little travel size bits, and I've had that out there.
It was sunny up there at the elevation.
It was sunny. I know. The one thing I didn't have, and I need to order, is the sunscreen. The sunscreen moisture? Yeah. I got it. It's good. OneSkin is more than skincare. It's about skin longevity.
targeting the root causes of aging to help you look and feel your best at every age. So get started today with 15% off using code AskGeorge at oneskin.co. That's 15% off oneskin.co with code AskGeorge. After you purchase, they'll ask you where you heard about them. So you can support our show and tell them we sent you. It's time to expect more from your skincare routine. Invest in the health of your skin with OneSkin.
So let's go to the second chart. This is why this second chart shows that there is still room for prosecution of Donald Trump.
And that's for unofficial conduct.
And for some potential official conduct. Okay, let's look at this. This chart was prepared by Ryan Goodman of NYU Law School, who runs this wonderful website called Just Security. And this is just another expression of what Asha did in her chart, but it actually goes through the specifics of the case as the court addressed it. So, okay, if you have official conduct, you go down and you ask the question, is it core presidential authority? If it is, there's absolute immunity. And here, the pressure on the Justice Department was held to be core and not prosecutable, which I strongly disagree with. Now, as for the rest of the official conduct, there's a presumptive immunity, and here, the question is again: does this pose dangers and intrusion on the authority and functions of the executive branch? If it's yes, then there's immunity. If no, then you can prosecute. And here, the court said that it dealt with the communications that Trump had with Vice President Pence, and they said, "Oh, the conversations that Trump had with Pence, those are official acts because the vice president is the vice president and the president is the president, and they're talking about the vice president's powers." And so therefore they remanded, they said this could pose an intrusion, but we'll let the district court figure out whether this poses such a sufficient intrusion on the authority of the executive branch that we will deem it, it should be deemed immune. The problem with that is, it makes no sense here. That ruling, leaving that open, is ridiculous because what they were talking about here did not involve any use of executive powers. This was the ceremonial power of the vice president acting in his capacity not as an executive official. In fact, the vice president actually doesn't have any executive power. He's not mentioned very much in the Constitution at all. But this is his exercise of authority as president of the Senate. Mm-hmm. He's basically exercising a legislative power here. And so the answer to this question should have been, even under this framework, accepting this complicated framework, the answer should have been no. There's no need for any fact-finding there. As a matter of law, this has telling the vice president to ignore electoral votes in his capacity as president of the Senate, a power he doesn't even have as president of the Senate, has nothing to do with the
core function.
Has nothing to do with this isn't a core function question. This is a question of whether or not this poses any danger to the intruding on the authority of the executive branch, because it doesn't it doesn't have anything to do with executive authority. So that, I think that this is going to get remanded to the district court, and the district court should be able to find, as a matter of law, that the pressure on Pence is chargeable. Mm-hmm. Okay, whether it's provable as a crime, that's for the jury to decide. And then for the other conduct you see on the right here is, okay, is it official or unofficial that the false elector scheme, is that official conduct or unofficial conduct? The court says, oh, we don't know, could be, yeah, and then remands it to the district court to find out. There is no way that could be official conduct. That's no more official conduct than Joe Biden standing on that debate stage, and it's not. It's campaigning.
Yeah.
It's about trying to win office.
Yeah.
He has no executive authority over electoral certificates, and certainly no executive authority to authorize a set of fraudulent certificates. And then the other thing is the ellipse speech, which prompted the crowd to go and rush up to Capitol Hill and commit violence. It's like, that's not the use of executive power. That's just ludicrous. And so what the court did here is, this is what I mean, it created this tremendous framework to decide for the ages, to create this beautiful structure, to decide every possible case, and then they applied the facts wrong. Okay, they didn't decide, they punted the case back to the district court, and then the one thing that they did actually decide, the pressure on the Justice Department, they got wrong. And then the rest of it, they should have just decided that. And what the court should have simply done is none of this. It should have said, we leave for another day the question of whether or not there is absolute or any kind of immunity for core official acts and other official acts. But we can say this is not official. This is not good faith. This is not these are not official acts that involve the use of executive power. And then the Justice Department piece of it, maybe that you could remand on and just say, the question there turns on good faith. That's the way I would have decided it. So basically, that's what I mean. It's just they basically took the facts of this case and they pretended that, they put blinders on and pretended that, oh, well, we don't know whether Donald Trump was really trying to look into the possible election fraud. We can't figure that out. We can't figure out what he meant when he told, people to go march up on the Hill. We can't figure out whether or not he was exercising official powers when he told people to create false documents to send to Congress. And we can't tell whether or not he was exercising executive power when he was telling Mike Pence to do something in his capacity as president of the Senate that he didn't have the power to do. And that's the problem with this case. It's basically they just didn't decide this case. And what they did decide of this case, they decided it wrong. And that said, he's still subject to prosecution because, as I said, I think there's
Trump specifically is still subject to prosecution because many of them couldn't be possibly considered official acts.
Right, but I don't think that the false electors scheme is anything to do with his official authority and exercise of official power. I don't think the lip speech was. The lip speech was essentially a campaign speech after the campaign was over, an attempt to overturn the election. It was it was not a speech in his capacity as president. I just don't see how you could say that. And because Vice President Pence was, exercising no executive power. As I said, the only executive power that you can say that the vice president has under the Constitution of the United States is the power to become president or acting president under certain circumstances under 25th Amendment of the Constitution of the United States. Other than that, you can look to the entire Constitution and you will not see any executive power assigned to the vice president. All you can see is that he is president, that he gets to preside over the Senate, and he can cast the deciding vote in the Senate, and that is not executive power. Now, it may be, as the court points out in its opinion, that there is, that the president discussing with the vice president whether or not he should vote in favor of a particular measure of legislation if there's a tie. Okay, maybe you can say that's executive power because it does involve legislation that the president ultimately signs. But this has nothing to do. This process, the electoral vote counting process, doesn't have anything to do with the president of the United States other than it chooses the president. And to have the president be able to try to coerce an official of essentially the legislative branch into basically committing a violation of the Constitution. I mean, that should be an act that can be criminalized.
And so that is what seems so. Adam Serwer in The Atlantic wrote, the court writes that presidents cannot be prosecuted for use of their official powers, but what it actually means is they cannot be prosecuted for their flagrant abuse of them.
Yes.
Right? So it's this idea of, and Sotomayor and her thing when she was like, immune. Her, what she was saying is like...
She's not wrong. And that goes back to the, that goes...
No matter how crazy the thing is you do.
Right. And that
now you're immune.
Right. And that goes to both you look on this chart, both absolute immunity and presumptive immunity. Absolute immunity, I mean, the absolute immunity goes to the president's decision to drop a bomb on someone. Okay, so let's say the president bombs Nancy Pelosi's house. Is that that's the exercise of Article I core power to order the Air Force to launch a missile strike? There's so many problems with this opinion, and because because it's deciding things in the abstract and not that it really has no business deciding, that aren't presented by the case. And instead of deciding this case was not a hard case and it should have just decided this case and left open the possibility, we understand that there's the potential for abuse, that there are core powers that Congress should not be able to interfere with through the use of the criminal law, and there may be unconstitutional laws and unconstitutional applications of those laws. And it's actually not a form of immunity. In fact, the professor I mentioned from NYU, he said it really wasn't immunity. It was just there are constitutional limits. And in fact, if you go and you look at the concurring opinion of Justice Barrett, and I think Justice Barrett, left to her own devices, would have written a very good opinion. She had to kind of concur to I think probably as part of a negotiation to get some other people onto the Chief Justice's opinion. But she explained that she suggested that she put immunity in scare quotes, as though to say, I don't really look at it. I wouldn't look at this if I were on my own. I wouldn't look at this as immunity. I would, look at it as basically just whether, as a pure separation of powers issue, whether or not there's an infringement of presidential authority. And she looks at it, I think she'd look at it much more narrowly than the majority does, even though she joins the majority opinion. And then she also does something very important here. She refuses to join Part 3C of the court's opinion, where the court does something I just think that's just completely indefensible, which is the court says that you cannot use official acts as evidence for that unofficial acts are criminal. So here, think about this. The president takes money to appoint somebody to an office, or takes a bribe.
Yeah.
Essentially, what the court is saying is that you can't have evidence of the discussions he had leading up to the appointment, because that's an official act. Now you can present money that money went into his bank account. You can present, and the only way you can present evidence that he actually, say, made the appointment or signed the bill is to look at the public record. Okay? You can't look at, if I understand the court's opinion correctly, what he told, what Nixon told Haldeman to do, or if he's acting through an intermediary and that intermediary works for him, those discussions are off limits. Even because its discussion relates to an official act. It's insane. And Barrett, Justice Barrett, rightfully calls that out. So I just can't join that piece of it. And I could go on about all sorts of other issues.
Let me ask you a couple of specific questions about the application of this. So is the Georgia case dead now because of this?
The Georgia case, no. The Georgia case is not dead because this involved attempts to lobby state legislatures and legislators into doing, and state officials into doing improper things, and that's not within the president's authority. I don't think those are official acts. I think those should be considered to be essentially. But
isn't this a question of what official acts mean? Because this is sort of the Nixon, if the president does it, it's not a crime. I think isn't Trump so immune under this that just him calling Brad Raffensperger, telling him to find the votes, they're like, well, that's an official act.
I don't think it's an official act. Okay. I'm not going to tell you that Justice Thomas or Justice Alito or some members of the court aren't going to take a different view. But I don't think it's an official act because I don't think he's exercising presidential authority when he does that. He's not speaking for the nation. He's speaking for himself, and he's acting in his own personal interest. So I think that those state law crimes should still be in play. But I hear you. I absolutely hear you. I mean, he's going to make arguments there, and we're going to end up with more satellite litigation about that.
Yeah. And so, obviously, we are not having this conversation in a bubble. We're having it after Joe Biden's pretty catastrophic debate, which I think alarms us about Donald Trump and his relatively high chances of being president again. But isn't this like a blank check for Trump to act with impunity in his second term?
Well, he will take it as a blank check.
Yeah.
And I think that's where, I do think that some of the language in the dissent is a bit overwrought, but but they're not wrong in the sense that Donald Trump will take this as an absolute ticket for absolute immunity on everything, and he may not. I don't think he'll be right, but at the end of the day, he's going to be president, and he's going to use this as an. He's basically going to everything he does. He's going to mutter the words "official act, official act, official act," and it's not a pretty picture, even though I think he still can be prosecuted for the crimes he committed on and leading up to January 6th.
Yeah, but at this point, now that this has gone back, right? Now that this has got to go back to decide the difference between the official acts, the unofficial acts, this delays this. I mean, Trump wins, he never gets tried for these things.
Well, yes, if he wins, but that was true at all events. Mm-hmm. It would have been true even if he were convicted. Okay, and as I've said and we've said in the past, the courts were never going to save us. They were never going to save us. Only we can save ourselves on November 5th.
Yeah. Okay. Can you explain something to me, though? Because I would say somebody who came up as a young conservative in sort of the conservative, conservatism Inc. world.
Yes.
Limited government, limited federal power. It's kind of at the core of what conservatives liked.
You think?
And so I'm a little surprised to see Roberts and all of the conservatives join this idea of such expansive executive authority.
I am too.
But what's going on here?
I can't tell you someday, 40 years from now, I'll probably be dead by then. We'll see the memos. I'll try to live that long because it would
keep
be
eating
exciting.
your factor.
Keep me in my factor.
You're doing your one
exactly.
skin.
I think someday we'll see exactly what the dynamic was when somebody bequeaths their papers to the Library of Congress. I think Chief Justice Roberts was trying to forge some kind of a majority here, and he had to accommodate some people with views I just can't even fathom. And the fact, I don't know. We may look back at these papers someday and see the dynamic and see what the initial positions of the justices were, and we may say, "Oh my God, Chief Justice Roberts did an amazing thing to preserve the ability of the Justice Department to prosecute Donald Trump," or not. I don't know. But the fact that he did get some of these justices who clearly, Thomas wrote this concurring opinion that's absolutely, positively idiotic. With apologies to idiots. In an absolutely idiotic opinion suggesting that the Attorney General cannot designate an independent special counsel. It's just idiotic. The Attorney General has the power to basically assign work within the Department of Justice. And if he wants to call somebody something, the official in charge of, watering plants, he can do that. It's crazy. These people who believe in expansive executive power, which I think Thomas does, and a lot of these conservatives of the current conservatives, right? They believe in executive power. You're saying that the Attorney General can't assign a case to one particular employee of the Justice Department? That's completely insane. Yet he actually puts this, it's not exactly the same argument that Trump is making that Trump made in Florida before Judge Cannon, but it's even dumber. It's an even dumber argument. And the next thing you're going to see is some kind of motion based upon Thomas's opinion there. So it's clear that he, that it probably was a great accomplishment for Chief Justice Roberts to get Thomas to sign on to an opinion that at least allows the theoretical possibility of a prosecution of Donald Trump. That said, this case could easily go up again, and there's going to be an opportunity for the court to review either pre-conviction or post-conviction, probably pre-trial or post-trial, to review these issues again. And I have little doubt that a couple of these justices are going to say Trump can't be prosecuted for any of this. And then you'll have to see whether or not the three dissenting justices, Sotomayor, Kagan, and Jackson, can bring over Barrett. And I think they can bring over Barrett, because Barrett basically pointed out that Trump conceded that certain, and the majority actually did concede, that Trump conceded that certain of the acts, Trump's lawyers conceded that certain of the acts were unofficial. The question is whether that's enough to state a crime. They're going to have to come back and take another bite at this. And that's going to, but that only happens if Donald Trump loses the election. But let me throw out one other thing that's sort of interesting here that's actually potentially important. By creating all of these issues for the district court to resolve, the district court could do something very, very interesting. And that would be to hold a mini trial to figure out what's official, what's unofficial, what poses a real threat to the operation of the executive branch and what doesn't. In fact, she's basically being instructed to do that. So what you could have when the case gets back to the district court.
And by she, you mean Chutkan.
Chutkan, Judge Chutkan.
This is who it's going back
yes,
to.
It's going back to Judge Chutkan. And, I'm not quite sure about the timing of this, because it's not, I think there's a certain amount of time before the case actually formally gets remanded to the district court. But she could just say, okay, next Monday, let's have a trial, a mini trial. And Jack Smith, you present evidence on all of these things, and basically you're having the same trial that you would have on the merits, except it actually would be broader, because you would include evidence that would probably be excluded as official acts or motive evidence.
But they would have to rule on.
But it'd have to be aired out.
Yeah.
You would have to have the testimony of all these people who, there's a lot of testimony here before.
Is this a real thing that could happen?
Yes. Whether it happens before November 5th, I don't know. Whether we want it to happen before November 5th is a political matter. I'm not sure about anymore, because I'd love to see all of this happen.
Yeah.
I'd love to see all this evidence dumped out in the public domain, because I don't think it's going to be favorable to Trump, and I think it shows you how sociopathic and criminal his conduct was leading up to January 6th. The only thing is, I think it's probably, my concern is, as we saw with the New York trial, was it gets him off the campaign trail. It might get him off the campaign trail, and then it might distract from Trump being Trump.
And what Trump's going to do in the future.
Because my firm belief is that if the campaign becomes about Trump as opposed to Joe Biden and his ability to stand on a debate stage, Trump loses, because that's why he lost in 2020, because it was about him, and that's why he won in 2016, because the election was about Hillary. That said, because this would be a mini trial, he wouldn't have to be present.
Yeah.
And his testimony is not going to be required. In fact, I think that, I think they'll not put him on. They'll put on the people they put on in the grand jury. And so we could have maybe the best of both worlds, where we actually get to hear some of the evidence, like what Pat Cipollone advised Donald Trump, and what Trump said and did on January 6th. Even if some of that might not be admissible in an ultimate trial or chargeable in an ultimate trial, it would be relevant to making the determinations that the Supreme Court has said that Judge Chutkan must make.
Yeah, so I think that's a really interesting prospect, especially because I got to say, I'm sensitive to the concerns about putting Trump, back in a courtroom. I got to tell you, though, the difference between the January 6th stuff and Stormy Daniels stuff in the eyes of the American public in terms of its severity is real.
Yeah.
Is real. Okay. We covered a lot of ground. We gotta go. We will come back and continue to do this. We did this kind of as an emergency. Right now, we will. There's a lot more to go over in this case as things unfold.
We should have some later in the week, and we can talk some more about the after effects of that.
All right. As always, George Conway, thank you for explaining the legal news to me and our listeners. Don't forget to hit subscribe, leave us a review on your podcast app, email us at askgeorgethebulwark.com, and we'll see you next week.
Well, George Conway, he's a man with a plan. Got to sit down with Sarah Longwell, take a stand, explain all the legal problems they're piling high. With Donald Trump, oh my, oh my, oh my. He said, Sarah, let me break it down for you. There's obstruction of justice, corruption too, the legal tangles and troubles, they're growing fast. It's a storm that's gonna last.